We are here. It's cause number F0389302, and this is -0-B. The state, Mr. Coleman is here, and is it Udishin?
Udishin, yes.
Udishin is here on behalf of the appellant, Mr. Garner. Just so that we're all on the same page. And ma'am, I'm sorry, what is your name? Thank you. Gilbert, you said?
Yes.
Thank you, Ms. Gilbert. And so what we're set for today, I want to take care of a couple of things. One, the appellant or applicant, I guess, what's the proper, what are you?
We're the applicant.
Okay, so the applicant has requested, filed a motion for some production of records. And Mr. Coleman filed a response, which I reviewed, to which Mr. Udishin filed a response to that, and I reviewed that as well. And I will let you both, I've read everything. I don't think we need to take a whole lot of time on this. I'll tell you where I am in general on this whole matter, and that is, I really think on both sides, whatever the experts need to look at before we get here for trial, then I think they need to look at that. And so I don't want to pick and choose and then later have the Court of Criminal Appeals say that I should have done something and we're back here doing this again. So I'm inclined to grant that motion. I understand your position, Mr. Coleman. If there's anything you want to put on the record outside of your response, I will allow you to do that. I think on behalf of both of you, whatever y'all need, I'm going to get it ordered so that when we get to the point where we're here for the battle of the experts or whatever it's going to be called, then everybody has had everything to look at and isn't going to stand up and say, well, I don't know because I didn't see something. So I'm willing to do that for both sides, whatever you need. Anything, Mr. Coleman, with regard to that specifically?
Your Honor, the only thing I would point out is that in the Court of Criminal Appeals' most recent case dealing with shaken baby syndrome or abusive head trauma, the Hobart case from 2025, from this year in June, the court made it clear in its denial of the application for a writ in that case that in order to obtain writ relief under these circumstances, the applicant must show new scientific evidence is available which contradicts, and I'm reading directly from that case, that contradicts the scientific evidence presented at trial. They made it clear that the focus is on the evidence that's presented at trial. In fact, I printed out.
Judge grants the records request. No more, we didn't see it. Now it's all heading toward a battle of experts, and the timeline just got real.
That's an inference from the plain reading of the remand in this case, that the Court of Criminal Appeals wanted the focus to be on the evidence presented at trial, and also if you look at this language from that most recent ruling from the Court of Criminal Appeals in Hobart, that was the focus, and I likewise would ask the court to limit the scope to what was presented at trial, Judge, just so that we don't get far afield of what our task should be.
No, and I agree that we're going to stay on task. We've got to. I mean, there was a very specific remand, very specific questions to be answered. I'm looking at it now, and the part that I think at least allows you guys to look into this stuff. Now, what I allow in and what I find necessarily relevant at a future hearing could be very different, but I don't think we will know that, or the experts won't know until they look at everything. The part that gives me just a little more, I think, leeway or to get this information out there and to grant this, the way it reads is the trial court shall make findings of fact and conclusions of law as to whether applicants' allegations and previously unavailable medical and scientific evidence, and then we've got number 1, number 2, contradict what happened then. And so, again, we're not going to go down the whole any and all allegation. It's going to be with regard to the scientific evidence, specifically, obviously, shaken baby syndrome and what evidence there was. Just because something wasn't admitted in trial, I don't believe that is off limits, because that was a choice made by a prosecutor back then. And then, so we'll, which obviously was none of us were involved at that point in this case. So I appreciate the, and understand and don't completely disagree, but I am going to grant the motion for production and that was filed. So then the only other thing that I really want for us to nail down is some type of scheduling order for us to live by kind of between now and our date, which we have been granted the extension to
June 15th.
June 15th. And so June 15th date is obviously the date when the findings of fact and conclusions are due. Our trial setting is April?
March 22nd or 23rd.
I should know that, but I walked in without knowing. Can you look real quick and make sure we're working backwards from the right date?
And Judge, I have one suggestion when you're ready
Sure.
to make about all this.
Sure, go ahead while we're figuring that out.
First of all, we made a notebook of all the cases we keep talking about for the court. If this
That would be
would
great.
be helpful to you.
That would be great. And obviously, any case that's in here, Mr. Coleman, if you want to look through it, make sure those are cases so that if I'm referring to a case, you'll be able to do the same. But I do appreciate that.
And Judge, the Rourke case, which is the remand space one,
Right.
that was my case. The Horvath case that was just referred to is also my case. So I've been steeped up to my ears in shaken baby cases for the last 20 years. One thing, when I was litigating the Horvath case in particular, it was out of Ellis County, we asked the Court of Criminal Appeals to delay having to do anything on the Horvath case until the court decided the Rourke case. And I think maybe what we should do is ask the court to delay the resolution of this case until we get a decision on the Roberson case, which I know the court's familiar with the Roberson case, the death penalty shaken baby case from Anderson County.
Right.
But that's currently under a remand order back to the trial court that's real similar to the remand order here. And so a lot of the issues that we're going to have to address here on the Garner case are ultimately going to be addressed on the Roberson case. And if we,
I guess so. Just to make sure that but I guess the problem that I see with that is that it's fact specific. The questions are fact specific that the Court of Criminal Appeals sent down, that I'm to make a determination whether or not in this case certain facts, either if you take out, for lack of a more scientific way to put it, take out shaken baby syndrome, and was there enough other evidence, medical or otherwise, to sustain that jury verdict? And so I'm not sure I would understand, or I understand why another case at that point. I feel like we've got the law, they've remanded it, and it's a fact-specific remand for me to make the findings in this particular case.
Well, Your Honor, I agree. The real reason why I'm bringing this up is part of the state's argument, or at least what I gleaned from their argument, is they want to challenge the holding of the Rourke case. They want to make an argument that there really isn't any new science on shaken baby syndrome. If the court is not inclined to get back into the whole is there new science argument and just decide whether or not the Rourke case, the new science, applies to the facts of this case, which is the position that we think is appropriate, then I agree there's not necessarily a reason to wait for the Roberson opinion. But if the state intends to bring in evidence and try to relitigate or attempt to relitigate the new science question, then maybe we should wait for Roberson.
Mr. Coleman, I don't think so. What they've asked or told me to do is very, it's very narrow in my opinion. And so relitigating, we're not relitigating everything. Between now and our setting, I'm going to have to read the entire transcript because I can't make the decision that they're asking me to make and make findings if I don't know what other evidence there was. Specifically, I mean, they're saying if other evidence were presented, would it have, by preponderance of the evidence, meant that the applicant would not have been convicted. And so it's going to be necessary for me, number one, to know everything that was presented. The new science is what this is all about. I guess I don't want to misunderstand. I think y'all are kind of both saying the same thing, just different ways. Like it's going to be, you're going to have experts that come tell me, because of the new science, the by preponderance, you're going to have experts that might come say that, and I have to listen and determine credibility and what else was there in the trial and do it that way. So I guess I'm not inclined at this point to ask for an additional extension. I will talk with, Mr. Florence is here. You guys both, Tommy knows him, of course, but Gary, first names. Mr. Coleman, Mr. Udishin, Mr. Florence is sitting on the first row, who is our briefing attorney. And so I'll discuss all of this with him. And if there's some reason we feel like that would change or my opinion would change to ask for more time, then I'll get back with you guys and do that. But for now, let's at least work on scheduling as if we were going.
I'm sorry.
Your Honor, and if I may just briefly, I'm sorry to interrupt, Mr. Udishin. Your Honor, complete agreement with the court wholeheartedly. Just to put a fine point on that. Rourke ruling itself makes that determination, in my opinion, that it was a fact-specific determination. I'll read just briefly some excerpts from that case. Rourke states that there remains some controversy with regard to the quote-unquote new science, and that the consideration of the new science considered as a whole, specifically in this case, was determinative because this was, as they put it, a circumstantial case. In other words, a fact-specific determination about that case, which is not unlike the fact-specific determination the Court of Criminal Appeals has tasked this court with making in this case.
That's where I am.
No, I agree, Your Honor. Just for clarification, I believe the state has said in some pleadings on the Garner case that at least it appeared to me that they were intending on making an argument that there isn't any new science contrary to what the Rourke opinion said. And I believe what they're saying is they're quoting Judge Urey's dissent from some of these cases. And if they're intending on making that argument, then that's, I think, is inappropriate under the remand and the law at this point. And just so we know what to prepare for, I want to clarify that.
Judge, it's my pleadings. I think I'm the best person to speak on the intent of my pleadings. Your Honor, what the argument or the gist of the argument will be is that there's no consensus, Judge. There very well may be some opinions out there as to whether or not there is new science or in this area, but it's the state's position. We believe their experts that we bring will bear this out, that there's a lack of consensus in that medical field, in that community.
And it doesn't matter, and Your Honor, it doesn't matter if there's a lack of consensus because you have the Rourke case, which is the law in Texas. So it doesn't matter if somebody disagrees with the Rourke case. It's the Rourke case that we're talking about.
Right. And so, okay, so I think, at least for now, you guys know where I stand. And the position that I am in is I believe it's fact-specific with this case. I think you guys, I'm going to get you the production you need, whatever y'all need with regard to experts and production of any evidence that will help those experts come up with whatever opinion they're going to have. And then ultimately, it'll be a decision that I make in my findings and conclusion after hearing all that. So let's, and again, if there's some change in where I'm thinking on, or what I'm thinking with regard to asking for an extension based on that other case, then I'll let you guys know that real quickly. So with regard to what are y'all's thoughts? I mean, obviously on the normal cases we have here, I'm not doing scheduling orders. I want everybody to have plenty of time. Do either of you have some ideas on, do we need 2 months out, a month out? Do we need to meet every month until then? Do we need, what are y'all's thoughts on making sure that we're all on the right path to where we need to be going?
I've attached a proposed scheduling order to my motion requesting a scheduling order.
You did. Let me see.
And I would suggest maybe we kind of use that as a template.
Have you seen that,
I
Mr.
have,
Yudishin?
I have, Your Honor.
Let me get it pulled up and we can just,
While you're pulling that up, Judge, my thought process at least is to work backwards from our deadline of June 15th.
well, I think we would need to work backwards from the trial deadline. Between trial and June is all me, AKA Mr. Florence, and me getting my findings together. So once the trial's done, it's a matter of everybody potentially submitting their own findings that I review, and then we come up with our own. So I think we need to work from trial backwards, right?
I was thinking, so are we keeping the March hearing date?
Yeah.
Okay.
That's
Because
where we are. That they've given us until June 15th. So, I mean,
I was thinking that because we got moved out to June 15th, then maybe the hearing date would get moved out. My preference would be, Judge, to have a hearing date at least a month before the June 15th date. I guess that puts us like in.
no, we want it for at least that, if not more.
Yeah.
Now, at this point, I just as soon keep March. We all kind of agreed, I think, on that date, right?
That's a date that works for our witnesses.
And I think we looked, Mr. Coleman, at your schedule, and you didn't have an issue. Honestly, I'd rather just go ahead. I have that already on my trial calendar to not have jury and things like that week.
What was the date again?
Well,
I've got it on my calendar. Okay, so we're going to keep the March hearing date, all right?
correct. And so let me, yeah, let's do that. And then,
And Your Honor, if I could make one comment.
and you guys,
about-
y'all can,
Oh.
let's just work through this. I know it's habit to stand, and I appreciate it, but just for working on this, go ahead.
Your Honor, we're not opposed to a scheduling order. The real question is whether you're going to authorize depositions, interrogatories, and requests for admissions.
I'm going to authorize whatever y'all want to do.
Okay.
Honestly, on both sides. If y'all want to take depositions, I think any of that, hopefully, if I allow all that, it makes my life easier that week. So on both of you, whatever y'all need with regard to depositions, interrogatories, requests, admissions, whatever you want to do, I'm going to allow it. Obviously, if there's some super far-reaching request that someone has and there's an issue, then we can get something set for a hearing very quickly. We can also, if necessary, take care of some things since it's just us at this point, and we're not having to worry about having Mr. Garner here for this yet. We can do things by Zoom if we need to have some just you and I and Mr. Coleman and the court reporter potentially if we need to work on some stuff like that as well. So.
And to simplify things, my suggestion would be just to pick a date to end discovery, get all of those things done by a date, say 30 days prior to the hearing date, and not break it down.
I'm fine with that too. I don't want to micromanage. I'm not a micromanager. This isn't my kind of case typically where I'm doing scheduling orders and having to worry about all that. So if you guys, we could say February 1st or February 15th. What's the actual date of it?
Something on January 27th.
That's got moved.
Okay, that's the
to-
only thing that's
Sorry,
showing on the calendar.
Ken,
March
do you
20
remember our day?
March 23rd.
March 23rd. Okay,
And so I would suggest that we could
mid-February.
say complete all of the discovery by February 23rd,
me see
30
what-
days prior to the
Let me
hearing.
see what day of the week that is. February 23rd is a Monday. Mr. Coleman, any issue with February 23rd being, that's 30 days out for all discovery to be complete?
That kind of puts us on with the type of discovery, the deposition that I'm anticipating, it's a tight deadline, but Judge, I don't have any major heartburn about it.
The only other thing, so June, I don't want to, March 23rd is our day, and then that gives us 2.5 months, which probably is more than enough, Mr. Florence. If,
I would anticipate parties might submit proposed findings of fact and conclusions of law. It might take them a couple of weeks to do that. So that realistically will cut into our time. We have to work on it to analyze all that as well.
okay,
And that's included in my proposed scheduling order is the spot for the draft proposed findings of fact.
and I get that that's pretty much, 2 months to get everything done. Do you think that's doable on your end?
Your Honor, I think what will happen, we'll have the hearing. Under the statute, the court reporter has 15 days to prepare the report.
No, I mean if I make that deadline February 23rd.
That's fine. 30 days in advance of the hearing to complete those discovery processes.
Which is about 60 days, 70 days from now,
What my concern
with the
is
holidays.
The holidays.
So really, if you start at January 1 or 2 and get started, you've got about, 45, 50 days to get everything y'all are, is that reasonable?
I think we can do that.
I know that's, and then when I'm getting us past the holidays and being realistic about time expectations, I do want to make sure, if we need potentially, a couple of extra weeks or something for you guys to do your job and a couple of less weeks for us to do ours, I think we could make that work, but we would have to start looking at a new trial date real quick, as in today, and get that figured out.
We can do it, Judge.
Mr. Coleman, I know your resources are a little different.
That's right, Judge. Again, it's be tight. I prefer 60-ish days
Yeah.
to complete the entire discovery process.
Mr. Florence, ideas on that?
I was saying that if we needed to seek another extension from the Court of Criminal Appeals, like a third extension, we need some of this record.
I'm not inclined to ask for a new extension. The only thing I would be inclined to do is possibly move the trial by 2 weeks. But that lessens everybody's time, to include ours and theirs, to get their findings of fact by 2 weeks. Okay, so if we were to, do you have your calendar available here today with you?
I do, Your Honor.
So right now we're March 23rd. Let me pull mine real quick and see if we can find an agreeable date towards the beginning of April. And
I'm sorry, a date to change the hearing date? Okay, Your Honor, we will need to check with our experts. They're from out of state. We checked with them on the
sorry.
We checked with them on the March date.
Gotcha.
And they were available.
Okay.
We would have to check on a different date if you want to change the date.
Perfect. And I would assume you would have to do the same, Mr. Coleman.
Yes.
Let's do this then. Let me throw a tentative date out. If it works for everybody, then I will consider moving it to that date. And you and I can do this by email. We'll include Mr. Florence on that email. I'll send out an email that has kind of formally saying what the date is that I'm about to come up with. And then if it does not work, then the alternative is going to be the dates we're talking about right now, which would mean a trial or hearing date on the 23rd of March, discovery complete by the 23rd of February. So as of now, let's make that where we are. And then if we can,
Defense wants the full science. The state wants limits. The judge says, get everything, stay on task, and be ready when the hearing hits.
I would say either the 6th, the week of April 6th, which is a Monday, or the week of April 13th at the latest. Those would be the two alternative dates.
Yes, those dates work for us if they work for our experts.
Okay,
We'll
Mr.
check.
Coleman.
Same.
So why don't y'all do this? I'll get an email out either this afternoon or tomorrow with everybody involved in it with those 2 dates. If we can get one of those that works for everybody, then I'm willing to push it back. If there's one of those that does not work, then we are where we are.
And we're fine with the date as is.
No, I understand that. I do want to give, Mr. Coleman is in a much different
I
position.
understand.
He's here with me an awful lot in court, and so his time and resources, I think, are a little different than what you guys probably have going on, and so I do want to give him a little bit of leniency if possible to be able to work on this, as well as the other very serious issues that he's working on daily with me. So I'd like to get it moved for him if possible. So if y'all could, I'd like to also have this nailed down before Christmas. And so if you guys can take the next few days and early part of next week to get with those experts, and we'll have an email going, and if we can get everybody on board, by the 23rd, that would be great if possible, so that you know what you're working with as soon as the first hits.
Okay, that'll work.
Yes, sir.
Just one thing, you mentioned something I hadn't contemplated, but if the court reporter takes 15 days to get the reporter's record ready, and then the parties take another 15 days to get their proposed findings of fact and conclusions of law in, that might leave us only about 3 weeks to get what we need done. That's probably sufficient and pretty quick, but this is a big case. I know everyone will be familiar with the record by then,
Right.
but depending on what the proposed findings of facts are, it's putting us, we might be in a 3 week, I was doing a rough calculation, I might be wrong, but.
Let's shoot for the 6th. Let's take the 13th out. And so if the 6th works, that would be amazing. I would like to be able to do that for everybody. If for some reason it does not, then the 23rd will be our day, with the 23rd of March being our hearing day, 23rd of February being the deadline for discovery. Okay?
Yes, Judge.
Anything else?
Judge, another important milestone for me at least is the designation of experts. I know that there have been mention of experts, but I prefer to have them a hard date, that they be designated, so I know who to send discovery to.
Any,
And I'm
That's what I
fine,
propose.
I'm sorry, I'm fine, we do need a date.
yeah, for both of you to turn those,
I don't know,
what are you suggesting? What's it, either?
Well, let's say we're working from February 23rd, discovery deadline.
Let's do it in number of days. So if your discovery deadline's 30 days pre-hearing, then designation of that way, if we move the date, I'm going to be able to count the days. You know what I'm saying? So designation of experts, how much before the discovery deadline?
In my mind, Judge, I'm thinking 60 days gives me a wide enough window to drop the discovery and have enough time for the responses to come back. And also
60 days
before
hearing.
the completion or the close of the discovery deadline in our scheduling order, if that makes sense.
That's next week. That would be next Tuesday.
A little quick.
That's not going to work. So
That's just my preference.
no, I understand. So why don't we make it?
I'm sorry, but if you think about it, those discovery, and it's been a while since I've done similar discovery, but those discovery deadlines have deadlines. If I drop discovery on their expert, it's typically a 30, 45 day, and Mr. Udishin, help correct me if I get it wrong. You've probably done more than this type of stuff than I have, but 30 days for them to respond.
I mean, and so here's what you've already talked with experts. You're calling them to see if they're available trial. You know who they're potentially going to be, right? So I don't think, unless there's something that you guys don't already have an idea, I would think at this point you've already got an idea who your experts are. So I'm going to make the designation of experts deadline January 5th, Monday, January 5th.
And Your Honor, we know who two of our experts are, because they're the two experts that provided affidavits that are already on file. We may have more experts, and because of the holidays, I don't think we're going to be able to determine that by January.
Let's make that still the deadline. I want everyone to get what you can by then. If we're going to keep the deadlines to be able to do discovery we've got to get that part done, or you're going to run out of time to get your answers on your discovery before we get where we need to get. So I'm going to keep that a pretty hard deadline. If you are working on something specific with regard to one expert says, hey, we need this other person, then I don't want anybody hiding behind the log on this. It is what it is. The experts are who they are. I want to know, everybody needs to know, let's get them out there. And if there's an issue, again, we can come back here, we can get on Zoom, or we can just email and say, look, I think I might have one more. I will know for certain by Tuesday or something like that. And I think everybody can work with that as long as I don't get the feeling that anybody's, trying to hide behind something to get something pushed back. Okay?
That's fine.
All right. Any other deadlines that we need to address?
The only other thing I think is really pressing, Judge, is the draft of the submission for the findings of fact and conclusion of law. Those other things I've listed in my proposed scheduling order, they're kind of like optional, like filing of trial briefs, preparation of trial notebooks, any additional pleas. Those are all things that are
Yeah.
I think are minor, but I think the submission of the finding of fact, proposed findings of fact, conclusion of law.
Well, that'll come 10 days.
Have to be after the reporter's record.
So once the reporter's record in, which is 15 days, so once we know for certain what our hearing date is, then I will be able to determine what that date will be. So it'll give you each 10 days after the reporter's record is due. And so I think that would be reasonable, whatever that date is, once I
Yeah,
get this.
and that's fine. I will say this, is that I've never really had a scheduling order in a writ hearing. Really, all we've ever done is list witnesses and then have a hearing.
And
then do our
again,
findings.
I don't want to micromanage. We're not going to go through, like Mr. Coleman said, all the things that are listed in that proposal. I do think it's important, though, that we have some of these key things, the discovery, the designation of experts. Those two things, I think, are very important, that everybody's on the same page. And we're not getting close to the hearing and somebody says, well, I haven't done something and we really didn't have a deadline and I'm still working on it. So I'm good with what we've got. I don't think I need to do anything else as far as scheduling. I've got us right now at a March 23rd hearing date, February 23rd discovery deadline, designation of experts, January 5th, and then the findings will be 10 days after the 15 days that the reporter has for the record. And then obviously if everyone can get that date approved for the 6th, then I will adjust those dates 30 days back, and I'll get all that to you guys in some type of email or order if you need an order.
Okay, I think that's fine.
Okay?
That's all I have, Judge.
Okay.
All right, thank you.
All right. Thank you all very
Thank
much.
you.
Have a good trip back. Thanks. Nice to meet both of you.